Okay, so a will is a document that somebody makes. The person making the will is called a testator, and they appoint executors to deal with their estate in their will, but also it's making sure that they can leave their estate exactly as they wish to whoever they wish. If they don't have a will, then their estate would pass under intestacy rules, which might not be the person's that they want their estate to go to. And a person's estate is whatever they own at their death, so whether that's property or accounts, personal possessions, any of it can be left to whoever they wish in a will. As I say, if you don't have a will, then your estate will pass under intestacy rules. Now, intestacy rules are set in strict order. For instance, if you're married with children, the first 270,000 of your estate would pass to your spouse, with the remainder being divided between your spouse and children. So if you've got an estate worth more than 270,000, then you've got the potential of your spouse owning property with underage children, who would need to be have trustees to deal with their side of the funds, and it all gets very complicated. There's also nobody who has got the power to actually do anything until a grant of representation is taken out. So the whole point of making a will is that you make sure that you've got persons to be able to do that for you. So an executor is the person that you choose to administer your estate, and their role and duties are to the estate and also to the beneficiaries. So they have to prepare an inheritance tax account giving the value of the estate, and that has to be submitted, and then they have to get in the assets from the various different banks, etc., and then distribute it according to the will. So they take liability for dealing with the person's estate, as that person wished. So in the UK, you can leave whatever you want. You can leave specific items, you can leave specific sums of money, or you could just leave what's called your residuary estate, which is what is left after everything, debts have been paid, any tax has been paid, and you can leave that into percentages or to specific persons, and it will cover all of your possessions and your assets that you have at your death. Okay, so you can leave your will to whoever you want to. In the UK, there are no restrictions as to who you leave your estate to. It could be individual people, it could be your spouse, it could be children, grandchildren, or it could be charities. And if you leave your estate to charities, then that is tax-free, so that would mean more money for your beneficiaries. But it is absolutely your choice who you leave your assets to. So you can put different things. You can put funeral wishes, you can put appointment of guardians if you've got children who are underage. You can put trusts into a will. That goes into a bit more detail, but there are various trusts that you could do, whether it's children who are between the ages of 18 and 25, or you could put property trusts in, which leave a life interest in the property to your spouse. So you can keep it as simple or make it as complicated as you want.